I'm former state prosecutor and criminal defense attorney Tom Grieve. Ever since the Rittenhouse trial has started, I've been getting a lot of questions about how does self-defense and provocation work together? Since this became a huge part of the prosecution's case, and since I see so much misunderstanding and frankly, bad information surrounding it, I wanted to take a few moments and do a bit of a dive. To really understand what provocation means, we need to actually take a look at the jury instructions. Now, the jury instructions are something that the jury actually hears. So this isn't exactly just a copy-paste of whatever the law or the statute reads. This is basically the law or the statutes more or less turned into kind of a layperson's language, or simply put, everyday English. So let's actually check out to see exactly what the Rittenhouse jury hears and what, frankly, most people might hear if a case has a provocation instruction. Wisconsin Jury Instruction 815 reads, in part, "You should also consider whether the defendant provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack and who does provoke an attack is not allowed to use or threaten force in self-defense against the attack. However, if the attack which follows causes the person reasonably to believe that he or she is in imminent danger of death or great bodily harm, he or she may lawfully act in self-defense. But the person may not use or threaten force intended or likely to cause death unless he or she reasonably believes he or she has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm." So there seems to be a profound misunderstanding about the fact of, look, if you actually do provoke an attack, does that mean you can ever use self-defense again? The answer is yes. However, the jury instruction puts some very unequivocal language around when and how. It says specifically that you have to exhaust every other reasonable means to escape from or otherwise to avoid death or great bodily harm yourself. Put another way, that means that if you're going to be faced with a deadly threat and if you provoked the attack, you better have done everything possible to retreat. So it more or less, in this particular instance, creates a duty to retreat if you provoked the attack. Now, this is going to be extremely important to understand because obviously, if you go out and if you attack someone, whether on the street, you go into their home, and you're the actual lawful bad guy, no question about it. If you actually disengage your attack and if you try to retreat, and if the good guy, the one who is the victim of the attack, actually chases you and hunts you down and then tries to use lethal force against you, you may actually be privileged to defend yourself against that original victim. If that sounds confusing, let's make it even more simple. If you provoked an attack, you've basically created a duty to retreat for yourself. Once you've exhausted your duty to retreat, and if facing a deadly threat, you can then use deadly force. I hope this quick look at the provocation law here in Wisconsin, specifically Wisconsin Jury Instruction 815, you found helpful. If you did, please consider subscribing to this channel for more great content. Also, please click like, it helps us with the YouTube algorithm, and comment below, what did you like, what did you not like, what other content would you like to see? Thank you very much.